Live.
Thank you. Ms. Spencer, will you open court, please?
Yes, ma'am. Part 1 of the Chancery Court of Davidson County will now transact the business which was created. All persons having business for this court, draw near, give attention, you shall be heard. God save the United States, State of Tennessee, and this honorable court. Circuit Court Judge Mary L. Wagner, Chancellor Jera S. Braun, and Chancellor Patricia M. Moscow presiding.
Good morning and good afternoon for those in the Eastern Division section of our state. Welcome to Davidson County Chancery Court Part 1. I'm Chancellor Pat Moscow. Sitting with me is Chancellor Jera Bryant from the Eastern Division and Circuit Court Judge Mary Wagner from the Western Division. This is case number 23-0336, Part 1, Consolidated, with case number 23-0395, Part 3. Now, Part 1. Metropolitan Government and Davy Tucker et al. Versus Bill Lee, Governor et al. We are here this morning for a status conference, and I am going to ask each set of attorneys for the parties to identify themselves and anyone who is present in the room with you. So I will begin with counsel for Metro.
Good morning, Your Honors. Allison Bussell on behalf of Metro. As you can see, the Director of Law, Wally Dietz, is also here on behalf of Metro. And in the room with me are John Whitaker and Melissa Roberge from the Department of Law. And then Bob Cooper is also on screen for the Metro government.
All right. Thank you very much, Ms. Bussell. And for the individual plaintiffs?
Thank you, Your Honors. This is Scott Tift on behalf of the individual plaintiffs, joined by Dave Garrison and John Spraggins, who are both visible on the screen here.
All right, very good. Thank you. And representing the state defendants.
Good morning, Your Honor. This is Timothy Simons. I'm one of the defendants, counsel for the defendants. I'm also on the separate screens are Mr. James P. Urban and Mr. Jonathan Shirley are also my co-counsel.
All right, thank you very much.
Mike Tackup on behalf of Metro. I'll be muted with my camera off. Thank you.
All right, thank you. Anyone else who is not identified?
Yes, I believe Mr. Simons forgot to introduce me as well. I'm Zachary Barker with the Tennessee Attorney General's Office on behalf of the defendants. I'm here with my camera off.
All right, thank you. And also present for this Zoom meeting with the Administrative Office of the Courts is the AOC Law Fellow, Jordan Emily, and the AOC Coordinator, 3-Judge Panel Coordinator, Danielle Lane. I think we have everybody identified now. And so we should be ready to proceed. The purpose of today's status conference is to develop a scheduling order for the progression of this case going forward and to see what each party's thoughts are about setting a final hearing date so that we can go ahead and get that on the calendar. So we need to discuss what needs to happen between now and then. We have a temporary injunction currently in place, and so I would like to just hear from each side as to what your thoughts are about how quickly this can be set for a final hearing and what needs to happen between now and then to be prepared for a final hearing. So I will start with the Metro government, Ms. Bussell, and Director Dietz, would you like to address that, please?
Sure, Your Honors. From our perspective, what remains to be done is you may have noticed that an amended complaint was filed late last week. We have been in communication with the state defendants, and we agree that their response to that amended complaint is due May 5th. I believe I'm getting that date right. Mr. Simons can correct me if I'm misremembering that. So the state will respond to that complaint by May 5th. Our plan would be at some point down the road to file some form of a dispositive motion. Our hope would be that this case could be resolved on motions. We don't anticipate needing any discovery from the state. We don't anticipate there being factual disputes that would necessitate a trial. And so I think it would just be a matter of determining how much time the parties would need for that sort of briefing. We think that it would certainly be most efficient to, if motions are going to be filed, sort of cross motions, for those to be filed and briefed and heard at the same time, just for the benefit of the parties and the court. And so we would just propose entering into some sort of agreed upon schedule to that effect. I think you're still muted, Chancellor Moskal.
I was. Thank you. And I agreed scheduling order that will include briefing and a hearing date.
Yes, we would suggest, and again, assuming the state agrees that this case could be resolved on motions, we would just propose some date that everyone would file those motions and responses and replies, and then those could be heard on oral argument, subject to the court's convenience, of course.
All right. Do you have a projected time period for that?
Given other things that we have going, I think a couple of months would be ideal. Of course, given the injunction, there is the urgency of the case has sort of slowed down a bit, which is probably to everyone's benefit. And so, we would look toward perhaps filing something in the next 60 days if the parties all agreed upon that, and the court, of course. That would be our preference.
All right, thank you. Let me hear from counsel for the individual plaintiffs next.
Yes, Your Honor. Again, Scott Tift for the individual plaintiffs. In general, individual plaintiffs agree with everything that Metro's counsel has just said in terms of how these matters can be resolved, not seeing any obvious factual disputes that should lead to a trial, and these being legal questions based on undisputed fundamental facts under the law. And so, the only, I think, procedural difference, which would certainly be up to the state, I don't know if there will be a motion to dismiss in the near future based on the court's reasonable likelihood of success analysis for standing as the initial plaintiffs. If that is the case, of course, that would be a separate process that would be, I guess, before, but also not, a different track than Metro, than a subsequent dispositive motion. So that would be the only scheduling hiccup that we're not currently aware of if we'll be there. I mean, of course, I think the parties could agree. Of course, you can't waive standing, and I think that could be, folded in with a single dispositive motion process on some schedule, like what Ms. Bussell suggested, or I don't know if or whatever the state says, and if there's any difference in sort of a time frame. I don't know that those necessarily need to be separate processes, but that's the only timing difference that we would see, or other procedure we would see, Your Honors.
All right, thank you. The only question that I have is whether the individual plaintiffs intend to file an amended complaint.
We do not intend to file one before. I believe the response date is Friday under just the default 30 days. We do not have an intent to file an amended complaint before that date. Of course, if unique issues were raised in a motion to dismiss, we may seek leave to amend to address those during the process instead of seek leave to amend in response. But we don't currently plan to.
All right, thank you. All right, let me turn to the state defendants.
Your Honor, the defendants agree that a speedy hearing under Rule 57 is appropriate in this case. As far as the issues that whether they can be resolved by dispositive motion, we tend to agree with that. This is probably a case that can be resolved on summary judgment. I will say a couple of things. One, in addressing Mr. Tiff's point, we do plan to go ahead and file a Rule 12 motion to dismiss on the standing issue with regard to the individual defendants. And as the court's aware, the timing of those adjudications don't track the Rule 56. They can be resolved sooner than than having a 30-day wait period. And we're not going to rely on anything outside the pleadings to file that motion. We intend to file that in the next few days. With regard to dispositive motions, we agree that a dispositive motion deadline is a good thing, with setting up maybe a final hearing on the dispositive motions, which would likely obviate the necessity of a final hearing or trial. We did serve some written discovery on Metro Nashville the end of March. That'll be coming due in the next week or two. At this time, we don't know if there'll be any additional discovery that needs to be taken, but there's possibility there would not be any additional discovery we would need. So as far as setting a timeline, 60 days, I think that would be okay, acceptable to the defendants, because that would also give us room if there was something in the discovery responses that we needed to follow up on, we could do within the period of time for the deadline for filing dispositive motions.
So are you looking at 60 days out would be the end of June? Is that what the parties are anticipating for a filing deadline on summary judgment motions?
Your Honor, that would be fine with the defendants.
Yes, I think generally that would be fine. I do want to follow up, though, just to be clear, we were assuming dispositive motions without the need for discovery. Our position is that the discovery that is outstanding, it requests things that are no longer relevant in this case, because virtually all of the discovery relates to the purported harm to the Metro government if the injunction were not entered effectively. And so our belief is that virtually all of that discovery has essentially been mooted by the court's ruling. And so if discovery is going to be happening, which we don't believe is necessary, then that would, I think, change that 60-day timeline, at least from Metro's perspective.
Well, I might suggest, and I'm happy to hear from Chancellor Bryan and Judge Wagner, I might suggest that at least Metro, you, Ms. Bussell, and Mr. Simons have a meet and confer regarding status of discovery and see what the needs of the case are from there. And then I guess if the answer is not going to be filed until May the 5th, then we'd be looking more correctly at the 1st of July for a dispositive motion deadline. Is that right? I was looking at May the 5th as the answer deadline for the state's response.
I would agree with that, Your Honor, and I might even suggest the week of July 10th, just given that the first week of July would be a holiday week. That might be more practical for all the parties in the court even. Again, just assuming we can reach some agreement that there's not going to be a bunch of discovery taken in those intervening 2 months.
All right, thank you. Would anyone else like to be heard? All right, Chancellor Bryant, do you have any questions? Would you like to hear from any of the other parties on any other issues?
No, but I view this as mostly one hearing for this case. And I don't think we need multiple dispositive motions that push off the final hearing. If I kind of viewed this as more having, if there's an individual motion, I think Mr. Simons mentioned standing of the individual defendants. I'm not sure that needs a separate hearing, but if you all want one, that's fine with me. But I don't think we need multiple hearings on multiple motions.
All right. I would tend to agree with that. Judge Wagner, do you have any questions or any comments?
I do not have any questions. I would agree. I think we could handle a dispositive motion or potentially cross dispositive motions in one hearing.
Including the standing issues.
Correct.
if any. Okay. All right. Well, what I would suggest then is that with the state's response date of May the 5th, that we move towards setting up a dispositive motion deadline. We can make it July 10th as suggested, unless defendants, did you have any alternative suggestion, Mr. Simons?
I think July 10 would be fine.
Okay, let's target that as a dispositive motion deadline. And then what I'm going to ask counsel for the parties is to put your heads together, meet and confer regarding the briefing schedule and if they are going to be cross motions, that each side's initial motion needs to be filed on the same day, supported by your memorandum filed at the same time, and a response deadline that applies to all parties, and then a reply deadline that would apply to all parties, so that those deadlines coincide. And then probably the biggest challenge is going to be finding a hearing date that works for everyone, for all counsel and for the 3-judge panel. So we're not going to be able to hammer that out today until we see what the briefing schedule looks like. But if you will, I'm going to ask you, Ms. Bussell, if you will prepare a scheduling order. And after you have conferred with all counsel on the briefing deadlines, and leave a blank for the hearing date. And without objection, I am assuming that we can hear the dispositive motions by Zoom. Is that agreeable with everyone?
That's fine with the defendant, Your Honor.
Fine with
All
Metro
right.
as well.
All
And
right,
also
and I
fine
think
with individuals.
good, excellent. And then that way we will probably have a little more flexibility in being able to get it scheduled more quickly. So that will be helpful. All right, is there anything else we can discuss today? Let me turn to you, Ms. Bussell. Anything else?
No, Your Honor. I am hopeful that Mr. Simons and I can work through this discovery issue. If there is just an unresolvable difference about whether discovery is necessary, would Your Honors propose that we just build in a discovery period? Do you want us just to alert the court to that disagreement? Again, I'm hopeful that we all agree there's not a need for discovery here, but I'm looking for your preference if there is not an agreement on that issue.
Well, I think currently with the dispositive motion deadline being 60 days out, I don't know that we need to add to that outside dispositive motion deadline to resolve any discovery. But if something remains unresolved and you need to file a motion, then file your motion and we can take it up.
Okay, thank you.
I
And
think,
nothing further from Metro.
Chancellor Moskal, I think that a discovery motion like that could be resolved by the presiding judge. I don't think it's something that the three of us need to get back on to decide, do you answer question 1 and 4 or not? I think that that's something the presiding judge should be able to handle. Do you agree, Mary?
I don't have a problem with that.
All right, well, we'll work through that if and when the need arises. And I appreciate that, Chancellor Bryant and Judge Wagner, so thank you. Let me complete checking in with polling everyone as to whether there's anything else we need to discuss today. Mr. Tift.
Your Honor, nothing further that we need to discuss. And just to clarify, we'll follow up with Mr. Simons and his team also. I mean, it sounds like whether a Rule 12 motion is filed this week or in 2 months, we'll be doing the hearing on it at the same time. So we're certainly amenable to saying, the response deadline is extended, so it doesn't need to be filed this week, or if not, at least working on how that affects a briefing schedule if we file our response at the deadline in a few months, or if we sort of brief that sideways. But I think we can have a call with Mr. Simons and team to talk through that.
We'll leave you to work out the briefing schedule for that, but the 3-judge panel preference is to hear dispositive motions, whether presented on motion to dismiss or motion for summary judgment at the same time.
Thank you. That's all for us. Thank you.
All right, thank you. Mr. Simons, any additional comments or remarks?
Nothing further from the defendant, Your Honor.
Okay, very good. Well, I appreciate everyone's cooperation and being available today. And I will look forward to getting your proposed briefing schedule and getting that scheduling order entered. We will confer among the 3-judge panel after we see what those dates are and have some proposals for hearing dates that will work for the court, and hopefully we can find some common ground on scheduling a hearing date as soon as we can. All right, and again, that hearing will be conducted by Zoom Gov, and I'm assuming at your request of the parties that we'll go ahead and live stream that hearing as well. Okay, we'll make arrangements for that in advance. Anything else, Chancellor Bryant? All right, anything else, Judge Wagner?
Nothing else.
All right, thank you all very much. I appreciate your time today. And
Thank
we
you.
are adjourned.
Thank you, Your Honor.
Thank you.